Welcome everyone, we'll get started shortly. Welcome everyone, we'll get started in just a moment, just waiting for everybody to join us. Just one more minute and we'll get started. And we are now live on Facebook as well. Super. So welcome everybody. Thank you so much for joining us today. For those of you who don't know me, I am Laura Skillen, the Executive Director of the International Mediation Institute. And we're also joined here today by Jess Lowe from the Singapore International Mediation Institute. So hi, Jess. So just a little bit of housekeeping before we get started. For those of you who haven't used Zoom webinar before, you'll notice that there's a Q&A function at the bottom of your screen, whether on your computer or on your phone. So if you do have any questions for our fantastic guest today, as he's speaking or afterwards, please pop them into the Q&A and we'll make sure to answer them in the Q&A part of the event. But with no further ado, I would like to, it was my great privilege to introduce Judge Aimé Karimunda, who's here from Rwanda to tell us all about the Singapore Convention on Mediation in Rwanda, which is happily a signing state to the convention. So welcome Aimé.
Thank you very much.
Are you looking for the share screen button?
Yeah, I'm trying to.
There we go. Excellent.
Okay, can you look at it?
Yes, we can see it now. Thank you.
Okay, good. Okay. Thank you very much for giving me this opportunity. I'm really very humbled, to be in this forum. It is very difficult to make a scope of mediation these days because it is an evolving field of law. We don't know yet where it is starting, where it will be ending. And the Singapore Convention on Mediation is one of the youngest convention of the United Nations system. So my intention is to share with you the work which has been done by Rwanda for a couple of years before and after the Singapore Convention. So I will look at small aspects, like why mediation now, how mediation can fit into the Rwandan legal system, and what is the rationale for adopting mediation today. So what will be the roadmap for an effective enforcement of mediation? We're looking at legal mechanism, institutional mechanism, and policies which are on the ground, and capacities which can propel the enforcement of mediation. So how can we really move from a domestic enforcement of mediation to international mediation? What will be the impact of the Singapore Convention on Mediation to the growth of Africa, economically and socially speaking? And today, what will be the way forward for Rwanda as we conceive it here? So we In Rwanda, we find out that there is a magic expression these days called the rule of law. And foreign policy experts, they're arguing that promoting the rule of law will certainly advance human rights, economic interest, will stabilize political regimes, it will be a response to social tensions. The concept of rule of law has become something like a run-up in the area of globalization and a prerequisite to live in a peaceful, free, and prosperous society. So it is the recommended remedy, in fact, to all the malaise suffered by countries, and mostly countries in transition from despotic regimes to stagnant economies. And we don't really have a clear definition of the rule of law, but the United Nations has recently provided a guidance saying that the rule of law refers to a principle for governance in which all persons, institutions, and entities, public and private, including the state itself, are accountable to laws that are publicly promulgated, equally enforced, and independently adjudicated, and which are consistent with human rights standards. In fact, the adjudicative process that requires special court decorum, unique attire from judges, prosecutors, and lawyers, normally characterized by the display of the law and concluded by an authoritative statement of what the law is, who has what rights, and how those rights are to be vindicated, represent the classic understanding of the essence of the rule of law. So the Chief Justice of Singapore, Honorable Sundaresh Menon, has however submitted that the classic understanding of the rule of law misses an essential ingredient, the principle of access to justice. Inability to access justice reduces confidence in the legal system as a whole. The rule of law is no longer exclusively intended to limit the tyranny of government. Its purpose is also and mostly to ensure that the citizens have affordable, efficient, accessible, flexible, and effective remedies to their disputes. In a globalized world where laws, cultures, customs, interests vary, we have to understand that the legal behavior is no longer the measure of moral behaviors. Morality today cannot continue to be reduced or confused with legality. So, in Rwanda, mediation, we don't take it as a foreign concept. It is fundamentally shaped in our historical context. Our country is directed to look at our traditional means of resolving disputes and build on while designing processes that are likely to address contemporary challenges. This vision is enshrined in Article 11 of the Rwandan Constitution, and this constitution encourages the lawmaker to adopt legal provisions that promote homegrown solutions. As Rwanda was confronted to the consequences of a genocide, it quickly discovered the limitation of the law and the law enforcement agencies. The development of alternative dispute resolutions is a response to the limitation of existing model of justice, regardless of the underlying philosophy, whether common law or civil law system, to name the few. Conventional justice in the modern style does not address today's needs of paying attention to the interests of each litigant and their good relationships. It is rather a justice that is built on the premises of individualism instead of community interest, competition instead of common interest, conflict instead of peace. The modern system is a remedy that is built on conflict. A famous French anthropologist, Claude Lévi-Strauss, he put it rightly, and he said that law has its origin in the pathology of social relations and functions only when there are frequent disturbances of the social equilibrium. That is what justifies the revival of flexible and diverse mechanisms of conflict resolutions as alternative to litigations in courts. This mechanism existed and still exists under our traditional law. Africa did not fully receive the important law. Traditional law still governs the majority of disputes in rural area in Africa, and mainly where access to modern courts is still difficult. Community leaders play a key role as decision makers. Justice is still communitarian since its primary goal is to maintain inter-community peace and harmony. These traditional mechanisms of conflict resolutions, they don't necessarily follow the Western principle of summa divisio. They are relied on in criminal matters, civil cases, as well as in commercial disputes. Archbishop Desmond Tutu, he says that the traditional African jurisprudence has always emphasized the concern of the healing of breaches, the redressing of imbalances, restoration of broken relationships, and a constant seeking to rehabilitate. The conflict is therefore seen as is seen in a perspective of rupture of relationship. The response to any conflict is not to establish who is right and who is wrong, but to establish something between. He calls it Ubuntu, equivalent to Ubumuntu in Kinyarwanda. Ubuntu in its essence is contrary to success through aggressive competitiveness, resentment, lust for vengeance, and retribution. It pleads for restorative justice. With mediation, the parties move from confrontation to cooperation. The values are similar to those in the first and the fifth preambles of the Singapore Convention on Mediation: amicable settlement of a dispute and contribution to the development of harmonious international economic relations. The coming of the Singapore Convention on Mediation has corrected Diamond's view that the relation between custom and law is basically one of contradiction, not continuity. Mediation is part of the Rwandan and African cultural heritage. In the recent past, South Africa and Rwanda have heavily relied on restorative justice in order to recover from the ashes of apartheid and genocide against the Tutsi, respectively. South Africa created a Truth and Reconciliation Commission, whereas Rwanda established the Gacaca courts. Gacaca courts are neo-traditional institutions resurrected from the Rwandan culture. The less formal process of Gacaca courts helped uncover a large part of the narrative for genocide against the Tutsi. The forum was unique in that it brought together victims and perpetrators. These courts were cost-effective for the state, victims, and witnesses. Proceedings were organized where the crime was perpetrated. Witnesses did not need to travel far to attend the court sessions. In some, Gacaca courts were a unique Rwandan solution to an unprecedented Rwandan problem. After the closing of Gacaca court, Rwanda took on and created the Abunzi conciliation committees that have jurisdiction over family, land, and other civil matters dispute of less than 5,000 euros. Gacaca courts and Abunzi committees have played an important role in bringing the component of mediation to modern justice. So when looking in the perspective of the judiciary, the interest of mediation, in Rwanda, Gacaca court closed on 18 June 2012, and they did not only help to establish the truth about what happened during the genocide, but also they provided justice, they promoted unity and reconciliation. They also tried 1,958,634 cases only in 10 years. The figures proves that this is an unprecedented judicial experiment. The Abunzi, on their side, are volunteers whose primary role is to reconcile the parties. The Abunzi committees strive to adapt traditional methods of conflict resolution to written law. The Abunzi committee has practically become the first level of the formal judicial structure. The judicial system portrays it as a remedy to the issue of a case backlog before primary tribunals. The Ministry of Justice indicates that from 2011 to 2015, for example, the Abunzi Committee handled 30.9% of cases that would have created case backlog in the judicial system. In the absence of the Abunzi, all these cases would have been dealt with through the formal system and they create case backlog. The judiciary, the Rwandan judiciary, is of the view that besides its other numerous benefits, an effective enforcement of mediation will reduce case backlog, it will increase access to justice, and it will improve the quality of judicial decisions. So this indicates how many cases we have had since 2011, and judges are always under the pressure of delivering timely decisions and well-articulated decisions. Because well-articulated decisions are it is the only way of increasing the reputation of the judiciaries all over the world, by the way. And this is clearly put by the justice from New Zealand, who said that the reputation of judges is very important because they lack the person and the sword. They are only armed with pens. Therefore, judges can only be effective if they are persuasive or authoritative to the parties before them, the legal community, and the public as a whole. But to be authoritative requires at the bottom a reputation for good decisions. So in Rwanda, when speaking to judges about sometimes the poor quality of decisions, they have a good argument. They say, we don't have time, we don't have a lot of things to do. So we think that if some cases were absorbed by the mediation process, whether out of court mediation process or court annexed mediation, so judges will remain with complex cases, and this would help judges to deliver rulings that would lead to the predictability of the rule of law. And this will not only increase the reputation of the judiciary, the confidence of the citizen, but also it will stabilize the rule of law. So far, Rwanda has tried to set up a ground for mediation at least at domestic level. It has worked on the legislation policies, it has built capacities, and it is reconceiving the role of legal institutions and stakeholders in order to accommodate mediation. Simultaneously, Rwanda perceives mediation in a big frame. Mediation is likely going to be the most effective instrument in resolving cross-border disputes in Africa and beyond. Professionalizing mediators, specializing in mediation advocacy, understanding the diverse international mediation practice models, relying on a multi-tiered dispute resolution, and embracing the online dispute resolutions are what will help Rwanda to effectively enforce the Singapore Convention on Mediation. So, as I said, we have already a very powerful basis for mediation in Article 11 of the Constitution, but there are limitations. Some of the limitations comes from the mindset of legal practitioners, the judges, the lawyers, and the other stakeholders who have been trained in an adjudicative way, in a way of a conflict. So bringing them on board in a way of creating another environment is rather a bit difficult. However, since 2008, the Chief Justice, the then Chief Justice, pushed to have a mediation started in commercial cases. And only in that year, in 2008, we had 883 cases so resolved through mediation in the commercial tribunals. So before ordinary court for civil cases, for administrative cases, for labor cases, it was a bit difficult. We had no legal basis, and we had, I think, a problem of convincing judges and even registrars to push parties towards mediation. In 2017, the Chief Justice again pushed, and I think he brought judges and mainly registrars to introduce a component of mediation in court, and he started a pilot phase. So the parties surprisingly welcomed the move, and soon we discovered that we needed private mediators, professional private mediators who could help the judges when when there is a collision between these policy of mediation and the policy of education within the court. But already having a pilot project propelled the legislator to include a provision in the new civil procedure code, where now under Article 9 and Article 72 of the civil procedure code, judges may encourage parties to use mediation if the judge believes that it is the most appropriate way to resolve the dispute. So before we did not have this provision. So I think the provision is there. We're using it, hesitantly because of what I said, the problem of philosophy, the way we studied, and the way we're heading to. But in several courts, we have judges who are really willing, to move towards utilizing mediation. And for pretrial conferences in all courts, we have registrars who have mandatorily to ask parties whether they should not mediate first. And since 2015, figures are increasing. You can look at figures. So these are mediations which were concluded in the registry without even going to the court. So parties, they come to the court because they believe that the conflict requires a very strong and a powerful decision, but they end up solving the problems themselves with the help of the registrar. So because the two provisions, Article 9 and the Article 72 of the Civil Procedure Code were a bit vague and not fully articulated. In 2019, the Chief Justice issued instructions that govern mediation. The instructions, they provide further guidelines to private mediators, to judges, to registrars, and they fill the gap in the field. They have defined the principles of mediation. They have determined the participant mediation. They indicate the stages of a mediation and the categories of mediation. Now, meanwhile, as the practice was going on, the Ministry of Justice with other stakeholders, they were working on a policy on mediation, which we are waiting it to be adopted by the cabinet. But the policy says that it aims to ensure that people in Rwanda effectively and satisfactorily resolve disputes with mutual understanding and play a key role in finding a collective and appropriate response to conflict and harm in the Rwandan society. So the policy says that it will be achieved through the design, implementation, and the development of a well-functioning, accessible, coordinated, and a sustainable alternative dispute resolution system that will operate in complementarity with the court system. It provides guidance and coordination to the structure for all stakeholders in dispute resolutions in a way that will help the Rwandan society to build on its tradition of using justice mechanisms to uproot the causes of conflict. So the purpose of the way forward is not only to deliver a judgment, to deliver a decision, is to uproot the conflict, the causes of the conflict or the causes of the harm. So the policy recommends two models of mediation, the out-of-court mediation and the court annexed mediation. Of course, we are expecting the resistance from the legal mind. That is normal, and that has happened elsewhere. But we know that people, as they are learning the benefits of the mediation, will embrace the system. So by now, the Chief Justice has this July published the first list of 50 accredited mediators, professional mediators, who we hope they are going to work in professional bodies, and we expect that likely from the next judicial year, maybe in September or October, judges from all courts can refer cases to these professional private mediators. So we believe that the way forward is to establish an independent body that will coordinate alternative dispute resolutions initiatives, promotion, capacity buildings and accreditation, professional development of alternative dispute resolution providers, as well as monitoring and evaluation practice. So these are elements that Rwanda tried without the convention. So now we are lucky, and I think the world globally is lucky to have the Singapore Convention on Mediation. We were not among the first signatures of the convention, but we quickly learned about it. And on 28 January this year, Rwanda signed the convention. I was checking with our stakeholders in the Ministry of Justice and in the Parliament. Apparently, the ratification might be on its way. So we might expect its ratification and the promulgation of enabling legislation very soon. And we hope that the enabling legislation would be based on the Initial Major Law of 2018. So the convention, we know that it applies to international settlement agreements resulting from a mediation, and that it aims to create a harmonized legal framework for the right to invoke settlement agreement, as well as for their enforcement. I think this is a very big move. So until now, Rwanda being traditionally a civil law country, we have inherited a provision, Article 44 of the law governing jurisdiction of courts, which speaks about the enforcement of foreign decisions. A formula which is commonly known as the exequatur. But the exequatur requires the parties who have been involved in a case in a foreign jurisdiction to initiate a fresh case here, and meaning it will consume time, it will consume money, and it will end up indeed being a disappointment. So we look at the Singapore Convention on Mediation as an instrument that will boost business, not only within Rwanda itself, but also between Rwanda and its neighboring countries in the region and beyond, maybe inter-African or international. And mediation is an alternative dispute mechanism for resolving dispute. It is not a threat to existing mechanisms. It's not a threat to court. It's not a threat to arbitration. It is, and the Article 6 of the Convention clearly provides for it, that in the case there are concurring claims between mediation and the arbitration or court system, so the local authority can discretionarily decide to adjourn the enforcement of the mediation while waiting for the local bodies to take the right decision. So when we are looking at a convention to the level of Africa, we found that in 1929, the African Development Bank was expecting the African economy to grow this year by a 4.1% of GDP. it would have been an increase of at least 1% compared to the provision of 2018. In that same year, in 2019, the economic provision for Rwanda, the growth of the GDP was 80.7%, higher than the regional average. The growth was mainly in services, 7.6%, and in industry, 18.1%, and particularly in construction. So the public investment was the one which draws growth because it is investment in infrastructures, in roads, in hospitals, schools, and so on. So the real GDP per capita would increase by 60.1% in 2019. Although the economic figures are very promising for Africa, at the same time, Africa lost 100 billion US dollars in the American AGOA deal. And the African Development Bank, as well as the World Bank, indicates that one of the problems of African economy today is the fiscal deficit, account deficit, and unsustainable debt. The economic disruption provoked by COVID-19 has pushed Rwanda and the world's growth projection down. However, it is still estimated that Rwanda and the East African region will perform better this year and next year. The African Development Bank has projected an average growth of 1.2% at the end of 2020, and this will increase it to 3.7% at the end of 2021. The projection is based on the scenario that the virus is contained at least by December 2020. If the pandemic persists until December 2020, the growth is projected to 0.2%, which is still above the Africa's predicted average of -1.7% and -3.4% under the two scenarios. Before the pandemic, and we have to remain positive that we will contain the pandemic, the African Development Bank was encouraging African countries to continue generating decent jobs. Macroeconomic and employment outcomes are better when the industry leads growth. In that perspective, Africa must eliminate, apply the bilateral tariffs, keep rules of origin simple, flexible, and transparent, remove all non-tariff barriers on Google and the service, trade on a most favorable nations basis, and reduce the time it takes to cross-border and the transaction cost tied to non-tariff measures. All these strategies need a new mindset that mediation, among other things, can trigger. However, in an international commerce, laws, including those related to arbitration, are controlled by those who have negotiating powers. Adjudication and arbitration are mostly favorable to big and powerful countries. These countries have developed rules, procedures, institutions, and experts in arbitration that are not helping commercial growth in developing countries. It is only mediation that would give to Africa a negotiating power in today's commercial dispute. With mediation, there is a win-win situation. Both parties negotiate to find solutions. An efficient and effective implementation of the African Continental Free Trade Area Treaty will require that African countries rely on new tools in negotiating business. This treaty intends to accelerate intra-African trade and boost Africans' trading position and on the global market by strengthening Africans' common voice and the policy space in global trade negotiations. We cannot afford this vision with old laws, procedures, and the mindset. A new vision requires new tools. African countries are therefore encouraged to include mediation in public and private contracts they engage in with companies and the other countries. In Africa, mediation is also adequate to economic integration. The movement of people and the goods will be smoother if there are smoother laws and the procedures that equally take into account the interests of partners regardless of their experience, powers, or relations. It follows that mediation is by now the only remedy that would ease into African trade and commercial relationships. It is a mechanism that is rooted in the Ubuntu philosophy. In fact, the Singapore Convention of Mediation is the translation of ideas from traditional African forms of dispute resolutions into contemporary practice. Mediation is a recognition of the African contribution to the transformation of a conflict in international commerce and beyond. With the outbreak of the COVID-19 pandemic, Africans engaged in online transactions than before. Soon after the lockdown, small and medium businesses as well as consumers are expected to continue buying goods online instead of taking risks of getting the infection, especially in countries that proved not to have consistent public health policies. In 2018, an estimated 1.8 billion people worldwide purchased goods online with a global e-retail sales amounting to $2.8 trillion US dollars, projected to be $4.8 trillion US dollars in 2021. However, with the COVID pandemic, the figures skyrocketed. According to a recent study, in March 2020, 42% of the US population purchased their groceries online at least once a week. That is an increase of 20% compared to 2018 figures. According to data report in Rwanda, the use of internet has increased in the last 2 years. There were 2.67 million internet users in 2018. It increased to 3.31 million in January 2020, an increase of more than 8.8% per year. Before the pandemic, the internet penetration stood at 26%. Small and medium businesses owners, as well as consumers, have discovered the miracle of online transaction. They are unaware, however, of the place from where the goods are shipped and where and when in time, space, geography they have entered into the purchase contract. When a problem arises, these businesses and the consumers seeking redress may unexpectedly find themselves engaged into an international dispute. This applies as well to separated parents, one residing in Singapore, the other residing in Rwanda. It applies as well to a village chief in Nigeria who is dwelling on a petrol field and who has to negotiate with foreign investors or with government officials, as miners, people who are dwelling on a mining field in Katanga or somewhere in Congo there, who have to negotiate with multinational companies, with the government. In this kind of cross-border disputes, where they were speaking about businesses, consumers, dispute, family, mediation, intellectual property, investor-state relationship, interstate relationship, mediation is the only flexible, informal, and relatively cost-effective remedies. So, by the way of concluding, we believe that in Rwanda, the legal fraternity will quickly understand the usefulness of mediation and will quickly understand that the usefulness of mediation goes beyond commercial disputes, because the purpose is to build a harmonious, a peaceful, a coexisting society. And we believe that if we implement properly the Singapore Convention on Mediation, it will be helpful for the Rwandan business, but also for the African business and for the international business. So this is the few words which I have to share with you. I hope I have not abused of your time, with your time, Laura. And I thank you very much.
Brilliant. Thank you so much. That was definitely not an abuse of my time at all. That was absolutely fantastic. Just stop sharing that screen. Great. So thank you again. That was really interesting. And I really appreciated how you gave a lot of detail about obviously the Rwanda mediation scene, but you also embedded it in the context of surrounding African nations. So that was really valuable. Thank you. Now we have had a couple of questions come in, and if anyone else has questions, please do pop them in the Q&A. We do have time for a few. And so firstly, we have a question from Samuel. I'm not going to say your last name. I'm sorry, Samuel. I'm going to mess it up. But he would like to know, what are the procedures through which independent mediators will be resolving various disputes? And is there a law on those specific procedures?
Come again? I did not catch all the words.
It's okay. So Samuel would like to know whether there is a law in relation to the specific procedures that independent mediators will be using to resolve disputes.
Okay. Well, as I said, we have recently developed a policy on a mediation, a policy from which we expect to have a comprehensive piece of legislation, but we think that the piece of legislation should come to enforce to also, not only, but also to enforce the Singapore Convention on Mediation. So a comprehensive piece of legislation is still needed. It is still being worked on by, I think, the Minister of Justice. We don't have yet a comprehensive piece of legislation. However, we have a provisions from which we can rely in order to start a private mediation. Some of these provisions are in the civil, commercial, administrative, and the labor code. And these are the two provisions that I mentioned, Article 9 and Article 72, where judges can refer the cases to private mediators. Now, the problem we had, because we don't have a specific legislation yet, we don't have an institution which is organizing them, is to see how will these mediators, operate. Mm-hmm. So it is for this reason that while waiting for legislation, a comprehensive piece of legislation, the Chief Justice issued guidelines. So the guidelines are very clear. So they set up standards for mediation. They set up criteria for accreditation, and they provide procedures for operationalizing mediation. Mm-hmm. We are yet to launch officially the first group of professional mediators. I hope it will be very soon. So we think that it is better we launch it before we have the law, and maybe we can look at how it works and correct mistakes if there are any mistakes through the law at a later stage. I don't know whether I have given an answer to the question.
I mean, I personally think that was quite comprehensive, so thank you.
Okay.
And on a quick side note, do let me know if you would like any assistance from IMI, because we do support different countries in actually developing standards locally. So we're here to help if you would like. Now we've got another couple of questions. So Felix Manzi says that now that Rwanda is a signatory state to the Singapore Convention and hopefully will soon ratify the convention, do you think that mediation committees or abunzi will hear cases of value exceeding 5 million euros?
Well, so if I get the question right, is the competence of the jurisdiction of abunzi compared to mediation. Is that right?
From what I gather, yes. And it's specifically the monetary value associated with it.
Well, the abunzi, I did not go into much details. The abunzi are community mediators. They are they are at the bottom of the civil system for petty claims. But they are laymen. They are citizens who are elected for their wisdoms, for their experience in society. They are not trained lawyers. They don't have necessarily the legal mind which is required, or the formal training for dealing with big cases. So I don't think that the idea is to replace the Abunzi Mediation Committee with the new mediation model, but I think rather it is to absorb a part of the cases which would go to the court, because these cases, commercial cases and civil cases, family disputes, land disputes, and in some instances of a criminal dispute, instead of going to the court, they can be handled professionally by a private mediator. But this, I think, will not overlap to the work of the Abunzi. The Abunzi will remain there at the bottom of the society, but on the side, we have these professional mediators who might not even necessarily be lawyers, right? Because the skills of mediation you don't necessarily need to be a lawyer. Maybe at the end, for having a good settlement agreement, you might need the help of an expert, but for guiding people through their emotions, through all the procedures of mediation, sometimes we might need the skills of psychologists, the skills of politicians, people who have expertise in the political sciences, rather than lawyers. So, but what the Rwandan system intends is to create a professional body, and most of the people who are already accredited as professional mediators are in fact lawyers. So they are already in the bar. They are already members of the bar who can convince their parties that they can solve their cases through mediation. And if the parties are unwilling, they can continue with the two other options, arbitration or adjudication. So I think I'm not wrong to say that the Abunzi will not be replaced by the mediation.
That's absolutely fascinating, actually, because there's parallels in terms of what you see in Turkey as well, with the different tracks and different styles of mediation, including the sort of role of locally elected or wise persons. So very, very interesting. Now we have a question here from Florida Kabasinga, who says, do you think in Rwanda it would be best to start mediation with family matters while testing the waters before rolling it out to other areas of law?
Come again?
So do you think it would be best in Rwanda to start with family mediation or mediation of family matters before rolling out mediation to other areas of law?
Well, I really believe that for family matters, we should even make mediation mandatory. Mm-hmm. It should not even be an option for family matters. Because there are many reasons which can create a dispute between, let's say, husband and wife. So now, everything these days is online. So, there are, if the dad has committed mistakes or the wife has, misbehaved, there is no need really to put all these misbehaviors on Google. So in my humble view, I believe that for building a peaceful society, which starts, of course, by the family, it is important that we keep confidential family matters the way they should be. Mm-hmm. So I think the problem in societies today was the model for justice that we had. The model of justice that we had did not give opportunity to family members to solve problems without exposing them to the public. Mm-hmm. But if mediation can reach the same decision as the one to which the court would conclude, there is no reason really to go to the court. And in my humble view, that is a pressing issue. In my humble view, that is a pressing issue because it has not only an impact between the two litigants, but it also has an impact on their offsprings who are indeed innocent of the dispute. And that justifies further the needs for mediation in family matters. For me, if it was possible, all family matters should mandatorily start by mediation. And other matters, land dispute, I don't know, the contract of sales and whatever, they can wait. But if family matters, it is not only a legal issue. It is an anthropological issue, it is a social issue, it is an emotional issue, and sometimes judges are not really intellectually equipped to deal with these other issues which are not legal. And sometimes they are limiting themselves to the legal aspects. And whereas the real problem is not even really legal. So I think mediation is the best way for family dispute. And in a country like, I don't know I haven't made the research for other countries, but I think it is a modern trend today. There is an increase of divorce in societies. And of course, there is a cultural, we are borrowing a lot of from abroad, the internet has become more easily accessible, the TVs are easily accessible. So we are importing many things, some of which can harm our society. So there is a need really to go back to look at the roots of the society. And the family is the foundation of every society. And we have to look at what will be the best approach to protect the family. And I think mediation is.
Perfect. I love how much of an advocate for mediation you are. So we have another question here from Nadi Sial. He says, firstly, thank you. And is it possible to convince a state to compromise its sovereignty and trust a mediation procedure? Should a state have extra guarantees?
Well, again, I'm sorry, I think I have a problem with my network.
That's okay, sorry. So in the context of the Singapore Convention,
yes.
Do you think that states should have extra guarantees? Is there a risk to sovereignty, for example?
Well, I think
I've lost you.
Well, I think that is a basic question in public international law. I think a state which has engaged itself into an international treaties knows that it has surrendered part of its sovereignty as regards the content of that treaty. And of course, what we have to look at is not what we're losing. And I haven't seen states saying that I have lost anything by engaging myself in an international treaty. So I think we have to look at what are we gaining by joining the treaty. So there is no single state today which can operate on an island land. So we are mutually interconnected, and we need each other, and it has become more real today than it was in the past. So I think the concept of sovereignty that we had maybe at the beginning of 20th century is no longer the same as the one we have today, because the mutual interest has grown. And I think every state which engages in international treaties has to surrender part of something, and starting by accepting the jurisdiction of a foreign state on its own territory. So joining the Singapore Convention would mean, and I wish really, because I was looking at the ratification, I think we're still very, we still have to wait again a bit. But I think every state which joins the Singapore Convention should in fact, for it, we should expect from it to enforce a settlement agreement coming from a foreign jurisdiction. And that state should set up a flexible mechanism enabling legislation that makes it flexible for the convention to be easily enforced. And in my humble view, it is in the benefit not only of the state where the settlement has been, adopted, but also in the enforcing state, because a convention which has been concluded in Belgium today, well, if I enforce it, there is this principle for reciprocity. It means that Belgium, because it is also part of the convention, is required also to enforce the conventions which will be settled in Rwanda. So for me, I think there is no problem.
Great, thank you. And so I think we've only got time for one more question. And so I've got a question here from Julia Namaharo, who asks, how can Rwanda disseminate information about conventions such as the Singapore Convention to the youth, to communities, to students and practitioners? So I guess that the knowledge around these conventions and around mediation in this context can actually reach the people who need to hear about it.
Well, I think in a country like Rwanda, it is not a big problem, because it is simply translating the content of the convention into the language that can be easily understood by the users. Mm-hmm. So I think that has been the problem, a problem of a disconnection between the legal text and the end users. Because the end users, they don't master necessarily these legal terminologies, which are so well framed and which are also so well loved by lawyers. But since this convention is a tool that will be used by those who are professionals and by lay people in law, I think it should be, I don't know who should do that, but maybe it will be one of the stakeholders, maybe the Minister of Justice, maybe the Minister of Commerce and the Industry, maybe the Judiciary, maybe the Mediation Institute, if it is there, maybe the Kigali Bar Association or the Kigali Arbitration Center. But whatever be the case, for me, that's not the problem. But for me, I think the term, the content of mediation, we own it. It is part of ourselves. It is part of our culture. We grow up with this concept. So the concept has been formulated into legal terminologies in this, so they call the Singapore Convention, but the elements, we own them already. So it is simple. It is to inform the citizens, it is to inform the public that these things which your grandmother was using, these things which your grandfather was using is now called this in Article 2, 3, 4, 5 in the Singapore Convention. So that will be the easiest way. But on the other side, I would love that, and that is sometimes the problem we have in developing countries. So we are late in developing academic modules for students to learn about legal instruments that are binding our countries. So I would maybe wish that the law schools locally, they look at if it is impossible to adopt modules on mediation, but they can still organize conferences, regional conferences or seminars with students, with lecturers, because as I said at the beginning, this is an evolving subject. It is not a subject to which we know the beginning and the end. It will be developing. So, so going through seminars, conferences would give extra knowledge to students.
Absolutely. Well, I think that's the perfect answer. So I'm sorry for those questions we couldn't quite find time for. Thank you so much for this absolutely fantastic presentation. We've loved having you here today. And I hope that we will hear more from you, and especially from Rwanda in future. So thank you.
Okay, thank you very much. Thank you.
All right. See you all next time.
Okay, thank you. See you.
Bye.
Bye-bye.